This was a factual hearing to determine the court needed testimony about my motion to dismiss the indictment. I made that motion months ago, and the issue for the court that's usually just made on the papers is, was the grand jury testimony so flawed as to require that it be dismissed? Normally it's just a review of the grand jury minutes that the court relies upon. In this particular case, it was a little bit unusual because the district attorney disclosed that, in violation of the Judiciary Law, that some of the testimony taken by this particular stenographer during this particular period of time may have been audio recorded. So the issue was, if there was an audio recording, and if so, what was was it enough to require dismissal of the indictment? Well, the stenographer testified, I think, quite credibly about what happened. She testified that some of the testimony that she took was recorded audibly, but if there was recorded testimony in my client's case, she wasn't able to find it. What I found to be the most sort of important testimony today was, if you were present and you heard the testimony of the stenographer, you had no doubt that she was telling the truth. I don't think that she was in any way misleading. But what was remarkable to me is, anyone, and I'm a prosecutor with 10 years of experience, everybody knows that you can't record grand jury testimony. That's the very first thing you explain to the grand jurors, and you make sure that the stenographer understands that, because that's a misdemeanor. That's a Judiciary Law misdemeanor. You can't do it. And the fact that the Genesee County grand jury never bothered to instruct its stenographers not to make an audio recording of the grand jury is remarkable to me. And what was even more remarkable is she testified that she's been doing this since 1997. So she said, in 22 years, no district attorney, Mr. Friedman or anyone else, has ever said to me, by the way, you can't make an audio recording of the proceedings. And not knowing that puts them in great danger, because every other court proceeding, it's perfectly permissible and, in fact, routine to make an audio recording of the proceeding. If you're a stenographer and you're doing a trial, you record everything audio in audio, so in case later you can go back and re-listen to it.
Right.
So she wasn't doing anything particularly unusual, and I'm sure that if someone had explained to her, if you make an audio recording of the grand jury proceedings that you're doing, it's a violation of Judiciary Law, I'm sure she wouldn't have done it.
Right.
But the fact that they never bothered to explain that to her is remarkable to me.